Hi, everybody. Welcome to the fourth installment in our webinar series. We are super happy to have you here today. I'm Ann Lotch. I will be co-presenting with Jane. We will introduce ourselves in a minute, but I'm just going to get us started here. This series that hopefully you've been attending all of and you're enjoying is funded by the Office on Violence Against Women. We want to thank the Department of Justice, Office on Violence Against Women, for their support of this project, and just want to remind people that the recommendations and reflections and stuff you're going to hear from Jane and me today is our opinions and not necessarily the views of OVW. I'm from the National Clearinghouse on Abuse in Later Life. We are the comprehensive technical assistance provider for the OVW Abuse in Later Life grant program. I know there are a lot of people who are attending this series who are from a community that has a grant, so congratulations. And we are committed to creating a world that respects the dignity of older adults and enhances the safety and quality of life of older survivors of abuse. And I will turn it over to Jane and have her talk about the commission.
Thank you so much, Anne, and thank you again for inviting us to collaborate with you on this series. Hi, everyone. My name is Jane Zai. I am the managing attorney with the ABA Commission on Domestic and Sexual Violence. The mission of our commission is to increase access to justice and safety for survivors by mobilizing the legal profession. So we provide free support around civil legal representation in cases involving domestic violence, sexual assault, and stalking. I will briefly describe a few of the resources that we offer. We have a number of publications, including most recently a guide on case selection criteria to help organizations think through which cases to prioritize when they are not able to assist every potential client who comes through the door. And we also have a new trauma-informed intake guide. We host 6 listservs. I will drop the link with more information about our listservs into the chat. So on that website, you can find information about the listservs and the applications for each one. We also provide one-on-one technical assistance. We can provide trainings to the attorneys at your organization or in your geographic area. We can refer you to local and national experts for help on your case matters. We can review your organizational policies to ensure that they are client-centered or LGBTQ plus inclusive. And we can help your organization with supervision protocols or intake procedures. So those are just a few examples of technical assistance we can provide. You can visit our website to request technical assistance or get more information about our publications, upcoming trainings, recordings from past trainings, and more. I will drop the link to our website into the chat as well.
All right, so today's topic is legal resolutions and remedies that might be available to older survivors of abuse. And then next week we have our final session when we're going to be discussing, really getting into the nuts and bolts of trial skills. So I hope you will join us for that as we wrap up this series for the year. And just a reminder, the sessions have been 2 weeks apart, but this last one will be 1 week from today. So mark your calendar.
I will review the overall learning objectives for the series. As a result of participating in this training series, participants will be better able to identify and describe key dynamics of abuse in later life, effectively recognize and respond to cases of abuse in later life, access client-centered, community-based resources, and provide effective client-centered information and advocacy to abuse in later life clients.
So let's get into Module 4, Civil Resolutions and Remedies. And Jane's going to just start us off.
The objective for today's module is by the end of the session, you will be better able to identify available civil legal remedies that serve both vulnerable and competent older adults. And this is specifically in response to physical and sexual abuse in later life, and we'll also be discussing financial abuse. My name is Jane Zai. I am the managing attorney with the American Bar Association Commission on Domestic and Sexual Violence. I have been with the ABA Commission for the last 7 years. I work on our training portfolio and I help develop our commission's publications. Prior to joining the ABA, I was a legal aid attorney for 5 years. I represented victims and survivors of violence in a variety of cases, including primarily order of protection proceedings, as well as other family law cases, including divorce, custody, child support, and kinship guardianship. I also served as a pro bono coordinator and I organized different legal clinics and legal fairs. And I will let Anne introduce herself.
Thanks, Jane. I'm Ann Lotch. I am the Justice System Coordinator for the National Clearinghouse on Abuse in Later Life. So I work with OVW Abuse in Later Life grantees and anybody else on issues related to older survivors and the justice system. So that involves training and technical assistance, providing training primarily to law enforcement, prosecutors, and judges. And then, of course, civil attorneys and legal advocates like we have today. In my prior life, I too was a legal aid attorney with Legal Action of Wisconsin, and I worked under a VOCA grant there, working with older victims of crime, similar to Jane, on orders of protection and other civil matters. So it is great to be with you guys here today. So we're going to have just a couple of housekeeping matters. We're going to have some breaks, some opportunities for you guys to participate in the chat. We're not using, I don't know if it shows up even. We're going to be using the chat for when we are asking questions. If you guys would mind just answering in the chat. We will have a couple polls during the session. And you are welcome also to submit written questions in the chat. We will be keeping an eye on that as we go along. So we will try to answer those verbally so everybody can benefit. And yeah, that's about it. If you have any, oh, this shouldn't say Mary Kate on there. Sorry about that. If you have any issues, tech issues, sound issues, whatever, just drop a note in the chat and we will try to resolve it if we can. So let's get into our content. If we could launch the first poll, please. Survivors of abuse have a number of remedies available to them. Many legal practitioners are familiar with traditional criminal laws related to elder abuse, like physical and sexual assault and financial fraud. But there are a lot of civil remedies that are available to survivors that may not be as well known. We're just curious to see how familiar you guys are with the civil responses to abuse in later life. So if you have used any of these remedies with an older client, we would love it if you could vote and let us know which ones. So we'll give you a second to do that. And just to go through the options. Oh, cool. All right, so looks like lots of folks have engaged in safety planning. Yes, we love to see it. And protection orders, kind of what I expected. Working with guardianship or APS, powers of attorney. Excellent. Oh, this is good. You guys have a ton of great experience. Well, those are some of the topics we're going to be talking about today and then also next week. So I'm glad to know that there are people here who have some experience in those areas. I am going to turn it over to Jane now.
So when working with a survivor of abuse in later life, a critical first step so a critical first step, and we've discussed this in previous sessions, is to engage in client-centered lawyering and trauma-informed lawyering to work with your client to determine what is their ultimate goal in engaging in litigation. As mentioned before, attorneys have to think of their clients as partners in the legal case, And while attorneys and advocates have a lot of knowledge about the law, as well as the procedures that govern family court proceedings, experts are the experts in their, or clients are the experts in their own lives, and what their hopes are and what their goals and objectives are. So before we get started, I will briefly mention a few ABA model rules. Model Rule 1.4b, permitting the client to make informed decisions regarding the representation, and Model Rule 1.2a states that a lawyer shall abide by a client's decision concerning the objectives of representation. So at the outset, attorneys should be advising clients of all of the options and the possible outcomes. Clients may not understand that there are options that don't include entering a courtroom. Attorneys representing survivors of abuse in later life will find that many older victims do not want to proceed to trial or litigation. As such, attorneys need to plan for litigation alternatives, such as engaging in negotiation. Engaging in alternatives to litigation may have the effect of putting the perpetrator on notice. Another litigation alternative is mediation, although it is important to remember that mediation is not always appropriate. Many state statutes or grant requirements may prohibit the use of mediation when domestic violence exists. So I'll make a few more comments about mediation. It's not automatically a bad thing or something that your client should not engage in if there's domestic violence. When mediation is appropriate, when the client wants it, the survivor might feel empowered through the mediation process. And mediation can be more flexible than litigation and can be more cost-effective and less traumatizing than litigation, particularly when the mediator is trained on domestic violence dynamics and can recognize and can attempt to equalize the power disparities between the parties. However, in mediation, the mediator is supposed to remain neutral. This means that they might not be able to address the imbalance of power. Because mediation is a more flexible process than litigation, abusers might be able to more easily use the process to perpetrate further abuse. As far as getting out of mandatory mediation, if that is something your client wants to do, they do not want to go through with mediation, the process will vary by state. Reviewing some of the statutes related to mediation, some states that require mediation will also have an out in the form of a judge waiving the requirement, and some states explicitly require that it shall only occur if the survivor requests it. During the course of litigation, whether you are focusing on reaching a negotiated agreement or you are preparing to go to trial, it is critical to safety plan with your client initially and then every step of the way. Attorneys have an ethical duty to keep their client reasonably informed about what is going on in the case, which includes informing their client of any pleadings and motions filed with the court and any conversations the attorney has with the abusive opposing party. Attorneys should also make sure that clients can get to the court and get to appointments safely. When it comes to safety planning, there are some steps that attorneys can take to mitigate a client's safety risk through using the law to help and developing relationships with other gender-based violence agencies in the community. I'll explain a little bit more about each of these strategies. Examples of lawyers being able to use the law to help include putting things in court orders, such as asking for firearms to be removed from the abuser's possession or sealing the client's address in court paperwork. And as far as developing relationships with other domestic violence or sexual violence agencies, some agencies may be able to provide advocates to accompany survivors to court proceedings, provide that support, or provide transportation to go to client meetings or to go to court. They may also be able to help provide other non-legal resources, such as food or housing resources. However, it's important to keep in mind that you, as a person who is making the referral to another agency, um, know whether that community agency can safely and effectively work with marginalized and culturally diverse clients before you make the referral. Also, you may need the client's informed consent before referring them. You should be safety planning with all of your clients who are survivors, and that safety planning should account for safety at home, in public, on the internet, and in emergency situations. The safety plan should include how you, as the service provider, are going to communicate with your client and what steps you should take if you are not able to reach your client. The safety plan should be specific, detailed, and practical, and subject to revision. Emotional well-being is also an important aspect of safety plans. The stress of litigation might exacerbate a survivor's existing mental and physical health illnesses or disabilities, and attorneys should maintain an open and continuing dialogue with their clients about their physical and emotional well-being. Survivors of abuse in later life may be eligible for a civil order of protection against the abusive party. Please note that this webinar is national in scope and does not address jurisdiction-specific laws or practices, so it might not even be called an order of protection where you are located. So our recommendations today are based on best practices and general state laws. Please review your jurisdiction's civil protection and general stay away order laws and procedures to inform proper local practice. I'm going to drop the link to the Women's Law website into the chat. So on the Women's Law website, you can click on any state and find more information about orders of protection and other laws and statutes related to both family law and non-family law topics. State laws do not include any upper age restrictions in defining physical abuse of adults. As long as the underlying incidents of abuse and the relationship between the older survivor and the abuser fall under your state's order of protection statute, the survivor should be eligible to request a civil order of protection. An issue to keep in mind when advising an older survivor is standing, specifically who has standing to file for a protection order for the survivor if they are not competent or able to file for the protection order on their own. Typically, guardians can file on their behalf, but power of attorney agents cannot file for survivors unless they have the express authority to do so in writing. In order to effectively represent a survivor of abuse in later life, attorneys should closely read their domestic violence statutes and case law and determine how their jurisdiction defines domestic violence. A lot of people who don't have as much legal knowledge might limit the definition of domestic violence to physical or sexual abuse. However, many, if not all, state statutes include behaviors that go beyond direct physical assault and include a broader range of offenses, such as compelling another by force, threat, or intimidation, restricting movement, threatening to kill or seriously harm, and stalking. So upon reviewing different state definitions for domestic violence or qualifying for an order of protection, some states list specific offenses that are not included in other state statutes. For example, the New York statute includes reckless endangerment, Rhode Island specifically lists cyber stalking, and Tennessee includes financial abuse, and a survivor can obtain custody of a pet through a temporary protective order in Tennessee. So it's very important to review the statute in your state and think about how different abusive behaviors might still meet your state's requirement for the domestic violence perpetrated, even if it's not explicitly listed. When you are looking at your state statute and requirements, you might find that not all survivors are eligible to request a civil order protection in your state, either because the definition of domestic violence was not met or the relationship between the abusive party and the order survivor does not qualify. We will talk more about both of these in the next few slides. It's imperative that attorneys know some alternatives if a civil order of protection is not going to be an option. For example, the survivor might obtain recourse through abuse and neglect, general stay away, or criminal stay away procedures. We also need to keep in mind that the circumstances in older survivors' lives or their living arrangements may require attorneys to be more creative in the remedies that they pursue. For example, the client might not want to kick out an abuser or obtain a stay away order, in which case an order of protection may not work for them. In those situations, client-led lawyering requires that we respect our client's decisions, even if we don't think that, even if it's not a decision that we would make, the client has the ultimate authority and decision-making power regarding their case. It is then our job to work with our clients to safety plan and to make sure that we do what we can to ensure that our clients remain safe. Likewise, you might find that an older survivor does not qualify for a civil order protection because a household member requirement is not met. Some jurisdictions define household members as people who live together or who have lived together. They might be roommates. Other states say that a person abused by someone who is their roommate, but no other relationship exists, cannot obtain a domestic violence order of protection. I believe most states, if not all states, will include in the definition current or former sexual partners. The relationship may also be met in many states by being family members, by kinship, or by marriage. Some states say persons related up to the fourth degree of consanguinity, and just a few states include caregivers as a qualifying relationship for a domestic violence order of protection. I believe it is Wisconsin and Illinois who include caregivers in that definition. Bottom line, some statutes broadly define family or household members, while others are much narrower. So again, it's really important to know your statute. We have discussed a few reasons why an older survivor will not be able to obtain a civil order of protection against their abuser because they do not qualify or because that is not what they want to pursue. We should then talk to our client and explain what options there might be and the advantages and disadvantages of each of those options. One possible option is a harassment order or a stay away order. So, for example, in Maine, survivors may be eligible to obtain a harassment order, even though they cannot obtain a civil protection order. Harassment orders allow victims to obtain protection against abusers with whom they are not related or do not have a romantic or intimate partner relationship. The drawback to these types of orders is that courts may not offer the same supports and resources that are available in domestic violence courts. They are usually for a shorter term, and they may have a different or higher standard of proof. And they may also not be governed by VAWA, the Violence Against Women Act. So there may be filing fees and fewer survivor-centered protocols.
Thank you, Jane. I appreciate the information on harassment injunctions too. We do have it. I'm in Wisconsin, and we do have that here, and it really is useful for those situations where they're not cohabitating and haven't had an intimate relationship. And we've had people contact us for guidance who are in different situations where they live in a jurisdiction and there's not an appropriate injunction available to them. So I appreciate that info. So pivoting to another important area for us to explore when we're talking about civil remedies available to older clients is healthcare autonomy. For many victims of elder abuse, this might be the thing that they are worried about most, even above their own personal safety or financial independence. It is really critical that attorneys who are discussing this topic with their clients, that they be prepared for a strong emotional response, because it's really important to think through in advance what types of referral information you can have ready when we talk about this topic. Talking about it can be a huge relief for that client, but they may also have real concerns about, what's going to happen to them and who's going to be making those decisions for them. So just kind of underscores why it's important for us to be really familiar with this issue and prepared to talk about it in a victim-centered way. In addition to, or separate from obtaining a civil protection or harassment order, survivors of abuse in later life can take other legal actions to protect themselves. One of those things is that they can assign a healthcare power of attorney, which is also a kind of advance directive, to name another person who's called the agent or the proxy to make decisions about their healthcare. This can also be part of a larger advanced healthcare directive under the Uniform Healthcare Decisions Act. It may be done with an attorney as part of estate planning, along with a will or a trust and a financial power of attorney. But a healthcare advance directive can serve as a preventive measure to ensure that an abusive person will not be able to make decisions about that survivor's health. If the survivor is competent, they can remedy any existing healthcare power of attorney or other arrangement to ensure that the abusive person does not have the authority to make those healthcare decisions for them. Attorneys who are representing survivors can also help clients to revoke a previously executed power of attorney if the agent becomes abusive or if the survivor was maybe coerced into making that arrangement in the first place. When you are representing clients and helping them to create a healthcare power of attorney, it's really a great idea to issue spot for signs of abuse against your client, and to ensure that the older person is making the directive freely and voluntarily, and is not being coerced by somebody else. One potential risk for survivors when making these arrangements is that the proxy, the designator, that the principal, so the client themselves, becomes incapacitated, and the agent subsequently becomes abusive towards the principal. In many jurisdictions, healthcare powers of attorney or advance directives may supersede other arrangements and be preferred in situations where the agent is abusive or becomes abusive over time. There are many benefits to healthcare powers of attorney, particularly for survivors of abuse. The principal, and again, that is the person who is granting the authority to make decisions over their health. The principal can direct their own medical treatment ahead of time and to protect themselves against the abusive decisions of third parties. And I think I'm going to talk about the difference between this and a living will in a minute, so I won't launch into that now. But basically, the principal is empowered to elect a decision maker that they want in place. They can, in most situations with healthcare powers of attorney, they can designate a guardian or propose a guardian should that become necessary down the road. Additionally, family members and doctors are going to know in advance what the principal wants done in the event of their incapacity, or should they need life-saving measures, things like that. And they can act accordingly. And that document is going to supersede any abusive partner's objection. So very important to remember that this document is essentially speaking for the individual. It is giving them, making sure that their voice is being heard later when they're not able to be heard, physically heard themselves. So you can see why it's really important to pick an agent that you trust and who is very familiar with your wishes when you are executing that. So you really want to carefully issue spot for abusive agents and empower your clients to revoke that power of attorney if that is the appropriate course of action. So even though healthcare powers of attorney can provide a lot of benefits to survivors of abuse in later life, they can pose some risks. It does give a significant amount of power to the designated agent, especially if that principal is seen to have limited capacity. So once again, just bringing up the importance of finding somebody and appointing somebody who is trustworthy and who is very familiar with the principal's wishes and who is going to follow those wishes. You can build in safety measures that can be incorporated into that power of attorney arrangement. But they're difficult, like having a third party review any decisions, things like that, but they are hard to monitor and enforce. There's nobody, when somebody is in a health crisis and you're at the hospital, there's not going to be a lawyer there taking a look at the document and making sure that everybody's playing by the rules. So enforceability is an issue. But if the survivor grants a healthcare power of attorney to an abusive person, it can really be a license to exert power and control over that survivor's life. The abusive person may deny treatment that the person didn't want, or may accept treatment that the person, or deny treatment that they wanted, accept treatment that they didn't want, that kind of stuff. Put them somewhere, put them in a facility where they didn't want to be. There are a lot of ways that that can be used to further abuse of an individual. So just be aware of that and of the importance of choosing an agent that is trusted and that is a safe person. Legal guardianship is another legal issue that can arise in cases involving older clients, younger clients too. Guardianship over another person occurs when an individual becomes impaired to the extent that they lack understanding or capacity to make or communicate responsible decisions. Generally, an individual is assigned a guardian when they become impaired by reason of mental illness, physical illness or disability, chronic substance abuse issues, chronic intoxication, or other cause. And it's really important to remember that a guardianship can only be ordered by a court. I know that, when I was working with older victims as a legal aid attorney, I had so many family members come in with an older individual and they'd say, "Oh, I can be in the room with you. I'm her guardian." But then they didn't have any paperwork that supported that. So you can't just become someone's guardian by saying that you are. That's got to be a court-ordered process. Someone who is assigned guardianship over an individual who lacks the capacity to make their own legal decision has the same powers, rights, and duties as a parent would to a child. We don't ever like to make that, draw parallels between older adults and children, but in this situation, talking about the relationship of a guardian to the ward, to the person who is under guardianship, it really is a position that requires a lot of responsibility. The guardian has the power to establish placement of that individual, to determine where they're going to live, possession of their personal property, making decisions related to their medical care, treatment, and any services that they might be getting, financial authority over the individual's finances. In some jurisdictions, there may be somebody else, those might be two different people, but this is sort of like the umbrella definition of a guardian's powers. But you should note that limited guardianship is sometimes an option. For example, in Wisconsin, we have kind of an opt-in guardianship form. So instead of unilaterally taking away the ward's rights, all of their rights with one swipe of the pen, there are check boxes. So you can retain certain rights. You can retain the right to vote. You can retain the right to have a fishing license, all kinds of things. So limited guardianship is something is an option and should be explored if that is something that you are thinking about. Establishing a guardianship can be really beneficial to survivors of abuse if it is appropriate, because a capable and well-intended guardian can protect an incapacitated victim from future harm by a perpetrator in an ideal world. For example, if an older victim who is married to an abusive spouse and does not have any legal arrangement in place may be further victimized by their spouse as they age and become less able to protect themselves. In that case, the victim could choose a trusted third party, such as a sibling or a friend, to be their guardian if they become incapacitated in the future. A good guardian can also pursue perpetrator accountability on a victim's behalf, because part of that guardianship authority is also being able to commence or engage in legal proceedings on behalf of that client, of that person who's under guardianship. If, for example, if a victim is incapacitated and they are being abused, the guardian can seek a civil protection order on behalf of that victim. Overall, attorneys representing victims of abuse in later life should work collaboratively with their clients to ensure that they choose a good guardian who's going to advocate for them, to seek legal protections for them, and who's really acting in their best interest. On the other hand, there can be serious risks to a victim of elder abuse if an abusive person gains guardianship over that individual. Establishing legal incapacity results in a serious deprivation of autonomy that is extremely difficult to reverse. The guardianship has to come from a court, and if it's going to be changed, that also has to happen in court. Guardianship gives an enormous amount of power to the agent. It essentially gives the abusive agent a license to exert power and control over that victim. Safety measures exist, and they can be also written into that guardianship order. Typically, guardianships are reviewed on an annual basis or some other period of time. But it is hard to monitor what's going on day to day when there is a guardianship in place. So as an attorney who may be seeking guardianship, it's really, again, important that you issue spot for potential power and control dynamics and empower your client, if they are competent, to make an informed decision in choosing a future guardian, and maybe writing some precautionary language into that arrangement to ensure their ongoing safety. So getting back to healthcare power of attorney, if somebody doesn't have a healthcare power of attorney, who is going to make decisions if they suddenly become incapacitated? I think there are a lot of myths surrounding this, because in some places, yes, it is a relative or a spouse, and it's written into statute. But other jurisdictions, that is not necessarily the case. So even as a spouse, you can't assume that that person is going to be able to make decisions for you. In some cases, a guardianship may have to be sought by the healthcare provider or somebody else. So just instead of going through this and saying this is definitely how it is, this is often how it is. But I would encourage you to know your local statute and know who the authority falls to if the individual is incapacitated, and then and then some kind of care is needed. So it can be any number. Your statute may be silent on this. I think the bottom line for me is that everybody, regardless of age, should have a healthcare advance directive that is current and that reflects your wishes. And if the person that you are designating to make those decisions for you no longer wishes to act in that capacity or is not available, you're going to want to update that. They're just really a critical document for anybody. So I will leave it at that. If your client is a victim of any kind of elder abuse, they may pursue a number of different administrative and civil remedies against professionals or institutions and non-professionals. For example, if an abuser solicits the assistance of a licensed professional like an attorney or a doctor or an accountant to commit fraud or any other wrongdoing against an older victim, you can report that wrongdoing to the Bar Association or sue for malpractice, medical fraud, whatever the professional might be engaged in, to whoever is required for licensing or supervising the wrongdoer. Your client can also seek recourse for the wrongdoing of non-professionals. For example, if a third party commits the tort of assault against an older victim, that victim may seek damages to account for the actual monetary harm and the emotional distress that they experienced. Moreover, if a non-professional commits fraud, breaches their fiduciary duties, violates the provisions of a trust, or wrongfully evicts an elder abuse victim, they could also have standing to seek recourse. So kind of heading in this direction. So let's get into financial abuse. I think when many people hear that we're talking about elder abuse, a lot of times they go straight to financial exploitation because it is so common. It is so incredibly underreported. And it simply makes the news more often than other forms of abuse, right? Financial abuse and abuse in later life cases, older adults tend to have access to resources that younger people do not. They may have their homes paid off. They may be getting Social Security. They may have a pension. And I think in a lot of abusers, they look at an older person and think, well, they're probably sitting on a pile of money. So they're more likely to be financially exploited than somebody who is younger. Older adults may also rely on other people to help them with financial matters, help them pay things like that in ways that younger people do not. So important to think of those things and to really understand why older adults may be targeted in that way. Older adults may also be willing to disclose financial exploitation more readily and more comfortably than if there's some other form of abuse going on. Like it's kind of, they perceive it as being less embarrassing, or there's less of a sense of shame for them attached to financial exploitation. However, again, going back to what you've been learning for the past 4 modules, we know that forms of abuse often co-occur. So really, in a gentle way, kind of issue spot for that, because if somebody is telling you that there's something financial going on, it is so likely that there are other forms of abuse present as well. But we talked, I think, in the first module about how being a victim of abuse can shorten somebody's lifespan. That includes financial exploitation, which always sometimes surprises people because you think, well, they're being financially exploited, they're not being physically harmed. Why should that impact their lifespan? It really does. They are 3 times more likely to die prematurely than non-abused people. There's something about that victimization, whether or not there's physical injury, that takes a permanent toll. So it is critical that we are poised to respond to all forms of abuse. In many cases, you're going to find family members who have access to an older adult's resources, and they legitimately need to expend an older adult's money on the older adult's behalf. There may be expenses like housing, medical care, anything else that you can think of, and that is totally normal. But there are some important distinctions to bear in mind. Did the older adult consent to that expenditure of funds or that transfer of property or whatever happened? Does the older adult appear to be the primary beneficiary? Like ultimately, even though this money was spent from their assets, are they ultimately going to be the person who benefits from that expense? Was the older adult aware that the expenses were occurring, that the assets were being used in the way that they were being used? Those are all important factors that can help distinguish normal expenditure of somebody's funds under a healthcare or under an advance directive or a guardianship and financial exploitation. Some indicators of financial exploitation are unexplained use or disappearance of funds or valuables, very dependent relationships. So say somebody is moving in with the older adult and all of a sudden they don't have a job and they're also their power of attorney. That would be a red flag for me. Transfer of property or savings, excessive payment to one person for care or services, or situations where the older adult is just unaware of the amount of money that they have, or the amount of money that is coming into their household and leaving their household. That should also be cause for concern. When you are looking at an older adult's financial statements, bank accounts, credit card statements, that kind of thing, one critical factor to look for is not only expenses that seem suspicious, but the lack of expenses that you would expect. Are there any expected expenditures that just are not happening? For instance, are utility bills being paid, medical bills, charges for supportive services, in-home care, rent, that sort of thing. That scenario, medications, if there's money that you would expect to be spent on an older adult's behalf that isn't being spent, that should also be cause for concern. So just curious about what your response would be based on the jurisdiction that you guys are from. What are some potential criminal charges that might be filed in a case of financial abuse in later life? So, and we'll go on to talk about some crimes, but just what are some of the things that you have seen charged when you've had a case of financial exploitation involving an older survivor? And I'll wait while you guys type some things in the chat. Conversion, easier to prove than theft. Excellent. We love conversion. Fraud, certainly. See what else you guys have handled. Doesn't have to be something that you have necessarily handled on your own, but some kind of charges. Senior consumer. Oh, nice. I have to look that up. Many states have an elder financial exploitation statute. That is terrific. Somebody is also mentioning they've had real difficulty getting law enforcement to pursue those cases. Unfortunately, we do live in a world where sometimes as soon as law enforcement sees a power of attorney, in their mind, they think it's a civil matter. And it is on all of us, everybody on this webinar, to spread the word that should not be the automatic response. It is absolutely possible and way too common for crimes to be committed with a power of attorney or guardianship. Theft by trustee, fraud. Ooh, you guys are good. You're on fire. I love it. So some of your answers. Forgery, fraud, misappropriation. I think you got a lot of these. Again, your statutory language is going to be different from place to place, but yes, these are some of the most common. And these are crimes that might be charged. We're going to have one more poll. How many of you have pursued any of the following remedies in abuse in later life cases? Any of these civil remedies with an older client? Just curious to see what ones you guys have accessed. I'll give you a couple more seconds. Okay. Let's close the poll then. Lots of guardianship, lots of revoking a power of attorney. Excellent. All right, good to know. Always good to know what your experiences have been. All right, I am going to turn it back over to Jane, who's going to talk about independent counsel.
So I'll talk briefly about independent counsel now, and another issue that might arise when you're representing older clients, which is conflicts of interest. Sometimes when you're representing older clients, attorneys may be representing concurrent clients. So both the older adult, called the principal, and a third party agent or beneficiary. While this is not ideal, and we will go a little bit into why, it is permissible in the ABA model rules when certain exceptions exist. So those exceptions are listed in 1.7b, which is on the screen. So what we are talking about here are the rules that lawyers must follow when they are representing two people on the same matter, which is also known as dual representation. Under Model Rule 1.7, generally we cannot represent a client if the representation involves a concurrent conflict of interest. If the representation to one client is directly adverse to another client, or there is significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. And then 1.7b goes into those exceptions. So a lawyer may represent a client if the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. The representation is not prohibited by law. The representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal. And each affected client gives informed consent confirmed in writing. So please note that the list ends with and not or, meaning that each of these four things must be met in order for a lawyer to represent both parties. So all lawyers have the duties of loyalty and confidentiality to all clients, but these duties are heightened in cases where the lawyer is representing an older adult. In these cases, the potential client may have limited legal capacity and may also be accompanied by a third-party caregiver. And in some cases, the third-party caregiver may actually be the abusive party. So the lawyer must refrain from sharing information with or taking direction from third parties claiming to represent the interests of the client, such as parents, adult children, or other caregivers, without the client's express and informed consent. But in cases where there is concurrent representation, when there is an older adult and the third party beneficiary, the lawyer has the duties of loyalty and confidentiality to both clients. This is why it's extremely important for lawyers to determine whether they are able to enter the attorney-client relationship with both parties at the outset. And if the lawyer does, then they must continually assess whether that relationship can be sustained. So the bottom line is, as we've seen from the model rules, concurrent representation is possible under circumstances where all of those exceptions are met. However, it is prudent for older clients to have independent counsel, particularly taking into consideration issues of capacity, domestic violence, and other forms of abuse. As we saw a few slides ago, concurrent representation requires informed consent. It's important to be especially aware around issues of consent and informed consent, particularly with older survivors, because while a lot of older adults do not have capacity issues, it is a possibility that it may come up as we age. So this slide lists some basic elements contributing to whether consent was actually informed, including mental capacity, how well you explain the advantages and risks of dual representation, how the explanation was provided, and how the consent was obtained. Again, we re-emphasize that attorneys must maintain client loyalty and confidentiality for older clients and for all clients, regardless of complications that exist or may arise.
All right, thank you, Jane. So another issue to consider when you're representing a victim of abuse in later life is the use of joint bank accounts. Joint bank accounts can certainly provide benefits to older adults, but also can pose some dangers as well, especially if the other owner of the joint account is an abusive person. Generally, a joint bank account owner has unrestricted access to all of the client's funds, all of the funds in that account. The older person's money could get caught up in the joint owner's legal battles. Basically, both parties typically own all of the money or have the right to all of the money in that account. And at the time of the principal's death, the person who established the joint bank account, the joint owner has the right to all of the money in that account, regardless of the terms of the will. So very important to remember. One option for older clients, including those who might be experiencing harm, is to create a durable financial power of attorney. A financial power of attorney is a written document naming another person, again, the agent or the proxy, to manage their legal and financial affairs. The agent can be anybody that the principal chooses. This is super important, particularly if the client's spouse or caregiver or child is abusive. The power of attorney can be in force immediately or when the principal becomes incapacitated. That's called a springing power of attorney. But typically they go into effect as soon as they are executed. It can be as broad or as limited in scope as the principal desires. So it may cover every possible kind of financial business transaction that exists in the world, or it can say, I just want you to have this checkbook and to be able to write checks out of this bank account or something like that. But, you know, it can have an entire range of authority that it is granting. So attorneys who are representing victims of elder abuse can use that flexibility in order to make creative arrangements that empower your clients and really limit an abusive person's power to the extent that the victim feels is necessary. When we say that the POA is durable, it means that when the person becomes incapacitated, its authority does not go away. Those powers are retained. And that just kind of underscores, again, why it is so important to choose an agent that is trustworthy and that is going to act in that person's best interest. Financial powers of attorney can cede a lot of power over the victim's, the principal's assets to the agent. The agent or the proxy may get the power to spend the principal's money, to cash checks, to receive income on their behalf, and to withdraw money from their account. But wait, there's more. They may be able to sell the victim's property, enter into legal contracts on their behalf, pursue insurance claims and legal actions. Really, any authority that that person would have had on their own can be granted to the agent by a durable power of attorney document. There are, however, some limitations that are placed on the power of the agent. The agent has to keep their own money separate from the principal's money. The agent cannot stand to profit from any transaction that they make on behalf of the principal. And the agent has to keep records, and provide an accounting on request of the principal or anybody else that is acting on the principal's behalf, like a guardian. So they're going to need to, at any point in time, be able to show their work and show that they are using the principal's assets in the principal's best interest, and that there is nothing hinky going on. Now, that is a great, that's great in theory, but again, there's not a lot of oversight. And in order to, it will take a court to come in and review the actions of an agent if it comes to that. So don't assume that that is happening, but they are required to keep records and provide an accounting when requested. Moreover, agents cannot make gifts of the principal's assets to themselves or to anyone else unless the power of attorney specifically states that gifting is allowed. There has to be a gifting clause in there. And typically, the gifting that is happening has to follow the principal's own habits that they've had over the years. For example, if I make Jane my agent and I've always given Jane $20 on her birthday, that can continue even if Jane is my agent. But all of a sudden, when I become incapacitated, Jane can't start giving herself $200,000 on her birthday. So again, it's got to follow the pattern and practice that the individual had before the power of attorney was in force. And then it's also important to know that the power of attorney can contain any other limitations that the principal chooses. They can decide that, there's certain authority they don't want them to have, certain authority they do want them to have. It really is an opportunity for some creative drafting and strategic thinking between you and your client. There are some safety measures that are built in. First of all, while the existence of a power of attorney is great, it does typically grant that authority immediately when it's executed, but it does not take any power away from the principal as long as they have capacity. They can still make decisions, they can still handle their finances, they can still sign contracts, sell real estate, all that kind of stuff. Important too to always remember that the agent is required to act as the principal would have and in their best interest. They do owe a fiduciary duty to that principal. Powers of attorney are revocable if the principal is competent. Attorneys can advise a client that is experiencing abuse or whose agent is acting in a way that they don't approve of by writing a statement such as, I revoke the authority of this person to act as my agent, and pursuant to any and all powers of attorney I have given prior to this date. And that's it. Just sign, date, and notarize that document, and then publicize it, have it distributed to anybody who might have an interest. So that would be, financial advisors, the bank, anybody else who would have to do with that individual's business. Again, this is what you would do if the person is competent. If they are not competent, it is going to take, I can tell you what would happen in Wisconsin. In Wisconsin, you would need to go to the court and request, a third party would have to go to the court and request a review of the agent's performance or request the revocation of that power of attorney. There are a lot of benefits to financial powers of attorney, as long as they are given to a trusted agent. So in an ideal world, one big benefit is that the principal can continue to direct their own legal or financial affairs while the power of attorney is in force. They also have the principal has the power to choose who the decision maker or agent will be. So we talked about it with healthcare powers of attorney or nominating a potential guardian should that become necessary. With financial power of attorney, it is, again, super important that the person trust the individual that they're giving this authority to, and that they are absolutely 100% confident that that person is going to act in their best interest. The other nice thing about powers of attorney is that they kind of prompt a discussion of information and dissemination of information between the principal, the attorney, and the potential agent, that can give you an opportunity to kind of see if there are any red flags for abuse, and give you an opportunity to advise that client and maybe do some safety planning if it is necessary. But It's great to be very thorough and hopefully not rushed in those discussions just because of the vast amount of authority that those documents are conveying. Similar to healthcare powers of attorney, there are some big risks for financial powers of attorney. They give a huge amount of power and authority to the agent over the older adult's finances. If the agent is abusive, it is essentially a license, again, like the healthcare, a license to exert power and control over the victim. Safety measures exist here, but just like with healthcare, they are difficult to monitor. So just reinforces again the importance of wisely choosing who that agent is going to be. If someone does not have a financial power of attorney, what happens if the principal, the older client, loses the capacity to make responsible decisions? Well, in an emergency, bills may not get paid. They may be hauled into court because of that. And without a financial power of attorney, a court may have to step in and appoint a guardian or a conservator. Can be an expensive and lengthy process. If someone is assigned a guardian or conservator, the older adult experiences a much more significant loss of independence than they would under a durable power of attorney. They lose all legal ability to make decisions typically. It does strip them of many more rights than having a financial power of attorney. And the court may choose somebody that the prince would not be someone the principal would choose. So once again, really good to get out ahead of this and talk to them about what their options might be and identify who is a safe person and who is not a safe person in their life. Victims or potential victims of abuse in later life can take some other steps to prevent abuse. And it's really a good idea to talk about these and again, recognizing that in the wrong hands, these can to some extent be used to exploit an older individual too. They may list a representative payee for certain payments, such as Social Security, VA benefits, or pensions, as an alternative to guardianship or conservatorship. Notice has to be given to the payor, to the entity that is paying the money to the client, but consent is not needed and court authorization is not required. The payee can be an individual or sometimes it's a social service agency. And this is generally used in circumstances where the older adult is legally incompetent or mentally or physically incapable of managing payments on their own. So it's really like just having somebody pay or represent you when it comes to certain benefits. There are some safeguards with rep payee situations that can protect an older adult. For example, the payee's authority to spending authority may be limited to current maintenance expenditures like food or shelter or clothing or medical care. So it could be just that they're only allowed to make payments that are related to a very specific narrow set of expenses. The payee might be required to submit monthly accountings showing what they've done on behalf of that client. Again, the payee has to keep their money separate. And they may be held personally liable for any misuse of those funds. Another option for prevention of financial abuse of an older adult is to assign a conservator to manage their finances and their assets. I know that we get into a sticky area with language here because there are some states where conservatorship means the same as guardianship, but here I'm talking about the aspect of guardianship that is only pertaining to the financial world. So a conservator can collect and retain assets of an older adult's estate. They can receive income. They can acquire or dispose of an estate asset, including real property. Conservators have the authority to borrow money and employed persons on the older adult's behalf, so hire a caregiver. The conservator can also assist in the prosecution of any crimes committed against the older adult's estate. So important if we're looking at potential financial exploitations. and they can defend any actions against the estate. Finally, if it's a large estate that your client has, the conservator can make gifts to charity and others as a protected person might have been expected to make in amounts not to exceed 20% of the income from the total income over a year of that estate. So while that sounds like a lot of authority and the conservator is granted a good amount of power, there are also some limits that are based on them, that are placed on them. For example, conservators may not make or change a will on behalf of the older adult's estate. They need specific court authorization to take certain actions, like making larger gifts. They cannot renounce interests or release powers or make gifts in trust. They can't create revocable or irrevocable trusts of property of the estate, which might extend beyond the person's lifetime or disability. Conservators cannot change beneficiaries under the estate's insurance and annuity policies, and they do not have the authority to surrender life insurance policies for their cash value. I just want to take a look at the chat really quick and see, can a financial POA? So no, I'm assuming, can the financial power of attorney be written to only become effective upon the person's death? Nope, I think that is not the instrument you would want to use for that. And I welcome anybody else to chime in on that. And when the person has a trust, yes, you can, if the person's assets are in trust and there is a power of attorney, you can tailor that power of attorney to reflect that there is also a trust in place. But a power of attorney is only, yes, as April correctly points out, is only enforced when somebody is alive. And that authority dissolves when they pass away. But again, that would be part of a larger estate planning picture. So you'd want to make sure that they've got a will and or a trust in place to determine what happens with their assets after they have died. So again, getting back to the slide, another option is a trust, as we were just talking about. A trust protects the older adult's assets. So the older adult selects a trustee, could be an individual, could be an institution. Lots of folks use banks to manage the trust. And depending on the terms of the trust, the assets can be distributed during the lifetime or after the death of the grantor. It really depends on how the trust is written. So they're pretty common, especially when individuals have special needs and aren't, maybe become disabled as a younger person. They may have their assets in a trust that for their care. Attorneys can look into special needs or pooled trusts that provide specific benefits for those people in that situation. Trust can be a terrific tool to protect an older adult from financial abuse, but it is a complex process. And I would be talking to somebody who has a lot of elder law, trusts and estates experience to do that. So just to recap, powers of attorney and guardianships have distinct legal authority. In a power of attorney, the principal retains their legal authority, whereas in a guardianship, the ward has no legal authority except that which they have retained, which the court has determined that is appropriate for them to retain. In a power of attorney, the agent must do as the principal wishes, regardless of the principal's best interest, whereas in guardianship, the guardianship is required to act in the ward's, the guardian must act in the ward's best interest. And the ward's wishes are only advisory. It may be, in fact, something the ward definitely doesn't want, but if it's in their best interest, the guardian has the authority to make that decision. And then finally, in a power of attorney, the agent cannot substitute their own wishes for that of the principals, whereas a guardianship requires the guardian to substitute their judgment for the ward's. I hope that that is clear. All right. So as an attorney who's working with older adults and older victims, you might find yourself exploring different recovery options to rectify financial abuse against your older client. Survivors of financial exploitation do have some options that they can pursue. They vary in degree of court involvement and intensity and difficulty, and you should work with your client to pursue the remedy that they feel the most comfortable pursuing. As we know, they are always the ultimate decision maker. To begin, survivors of financial abuse can close or freeze financial accounts or remove account holders. Survivors or their representatives can engage in negotiation sessions with the perpetrator of financial abuse to recover any lost assets and avoid the cost and strain of litigation. And finally, survivors can pursue a civil tort action for breach of contract, breach of fiduciary duty, abuse of confidential relationship, conversion, some of those crimes that you guys, or some of those civil remedies that you guys mentioned before, including fraud. And then some more potential ways to help somebody recover from that financial exploitation. They can pursue partitions, reformations of a deed, foreclosure, evictions when it comes to property and cohabitation situations if their property is being mismanaged. They can also create a constructive trust that governs the property or assets that are being misused or mismanaged. They may pursue civil remedies for the negligent hiring or supervision of the wrongdoer. Many times it's more fruitful actually for survivors to take actions against banks that did not follow protocol or follow their own instructions when it comes to a financial loss for the older adult. And then finally, if the older adult was the victim of undue influence, if there's coercion going on or improvident transfer of title, they can try to overturn the transaction altogether. I know that having one slide on this makes it sound like it's really simple and straightforward, which it isn't. And I wish we had the time and the bandwidth to do something really in-depth on these, maybe one of these days. So to overturn a contract on the basis of undue influence, and again, as with all of this, you're going to want to refer to your own state statute because all statutes are different, and I defer to your own state or tribal codes. But generally, to overturn a contract on the basis of undue influence, the older adult or their representative must show that the victim was dependent on the transferee, for example, by showing that they had limited mobility, vision, hearing, cognitive functioning, or major illness. They would have to show that the parties have a confidential relationship, meaning a familial relationship, a fiduciary relationship, professional healthcare provider, clergy, or just friendship. They would have to show that the older adult was without independent counsel, as we talked about earlier, and that this undue influence was taking place. So I'm going to turn it back to Jane now.
Thank you. So we are coming toward the end of our time. If there are any additional questions, please feel free to put them into chat box now.
Karen brings up a good, an interesting topic, is asking for examples of restorative justice. One thing that we often see, yes, I can explain what a fiduciary is in a second. One thing that you may see with abuse in later life and other types of abuse as well is that the person who is being harmed may not want their relationship with the abuser to end. Because when we're talking about abuse in later life, what we are talking about is abuse that occurs within the context of a relationship where typically we would have an expectation of trust. So a family member, a spouse, an intimate partner. a lot of times when we are talking to older survivors, they don't want to terminate that relationship. They don't want to cut their grandchild out of their lives. They don't want to leave their husband. What they want is for the harm to stop. So there may very well be opportunities for restorative justice here. You know, if you are confident that, and I don't know that I specifically have an example to offer you, but I think that if there are ways to empower that victim to be safe and to make sure that they are taking advantage of some of these legal approaches to protect themselves, that is entirely possible. If people have worked on cases where, yeah, we don't have a lot here. The person who asked the question is saying they're seeing a lot in action in Illinois. I know that Marquette Law School has some folks that work on restorative justice issues. But it is, and yeah, I think it can be it can be very difficult, but it certainly can be an option. And don't have any specific examples to give you, but I think if it can be very appealing for somebody, because as we know, the reason that an older adult might not want to seek any remedies or seek any assistance at all is because they are afraid of somebody they love going to jail. So it's important that we be aware of that. We use the term fiduciary a lot in this presentation, and basically a fiduciary duty is a heightened duty of care that you have to another person to act in their best interest. So you might hear or see ads for financial firms that are telling you, like, your money is safe with us because we are a fiduciary. Basically, it means they're acting in your best interest. They cannot take actions that are not in your best interest. So it is a heightened duty of care, and there are consequences for violating that fiduciary duty. Any other questions popping up for you guys? Jane, do you have any insight on the restorative justice question?
It made me think about when we were talking about mediation and other type of non-legal paths that are available for clients to pursue, and whether that might work better for what the client wants. And this is a little bit off topic, but I think sometimes as attorneys, we're very much focused on pursuing legal remedies, and that's what's going to work best. We've seen it happen, and this is going to work for you too. But in reality, what might work best for the client may be found outside of legal remedies and solutions. So I have not worked specifically on restorative justice initiatives as clients, but I think a lot of trauma-informed principles apply, and making sure that the solutions we are pursuing work best for the survivor and try to empower them the best ways that we can.
All right. Not seeing any other questions in the chat. This was a lot of dense stuff in a very short time. So if you guys have questions, oh, wait, you've got more slides to talk about. I'm going to shut up, Jane.
Revisiting the key teaching point for this module. Hopefully, as a result of participating today, you are more able to identify available civil legal remedies that will serve both vulnerable and competent older victims of abuse in later life. A little preview for next week, which is the final module of this series. Next week, Wednesday, November 20th at 1 p.m. Central, we will be working on developing some litigation skills in abuse in later life cases, including identifying and preserving evidence and testimony, utilizing a range of pretrial motions, and preparing witnesses for direct and cross-examination. And please remember that this last session will be taking 1 week from today instead of the usual 2 weeks between modules. I want to say thank you so much to everyone for participating in today's session. Please feel free to reach out. Both Ann and I have our contact information listed on the slide. So if you have any follow-up questions, or if you or your team have any training and technical assistance needs, please reach out and we would love to hear from you.
I do want, oops, I do want to say, somebody asked in the chat, in the host chat, if we had CLE credits for this. We have not sought them for this course, but if you want to apply for CLE credits on your own, please contact me, and my email is up there. And we can get you whatever it is you might need for that. Just let us know. The link for the slides and some other supporting materials is in the chat. Hopefully you guys see that. Did that go out to everybody?
I just sent
Yes,
it out to everyone.
Great. Awesome. Otherwise, we look forward to seeing you guys in 1 week for our final session. Thank you for all you guys for being here.